A very good morning to all of you. In this workshop on intellectual property rights and IP management for startup, organized by the School of Biomedical Sciences and Institute Innovation Council, Galgotias University. So let me introduce about the Institute Innovation Council first. The Institute Innovation Council of Galgotias University is established as per the norms of Ministry of Education Innovation Cell in the academic year 1819, and the IIC has organized more than 250 events till date on entrepreneurship, innovation, startup, IPR in the campus. And we are proud to be included as amongst 16 governing member of IIC Consortium Uttar Pradesh in academic year 22-23. The IIC of Galgotias University received 4-star rating by Ministry of Education Innovation Cell, Government of India in academic year 2021, 21-22 and 22-23 to promote the innovation and startup in campus by organizing IIC calendar activity, MIC driven activity, IIC celebration activity and self-driven activity. We are recognized in the band excellent in the ARIA ranking by the Ministry of Education and also secured 11 to 50 rank band in NIRF Innovation Ranking 2023. The IIC of Galgotias University is proud to be selected as Mentor Institute with funding support by the Ministry of Education Innovation Cell, Government of India in 2023. And we are providing mentoring support to 5 institutions, that is Gautam Buddha University, Greater Noida, Soviet University, Meerut, Raghunath Girls Postgraduate College, Meerut, Tikaram Kanya Mahavidyalaya, Aligarh, and SSB PG College, Hapur. The Galgotias University received certificate of appreciation by Ministry of Commerce and Industry, Government of India for the exceptional contribution in successfully organizing IPR awareness program and active participation in the National Intellectual Property Awareness Mission in various years. The Institute Innovation Council has also hosted the following flagship events like Smart India Hackathon, Hardware Edition in 2022 and 23, sponsored by the Ministry of Education and AICT. We have also organized Toycathon Physical Edition in 2022. We are among the 5 institutions in the Pan India who has hosted the Toycathon, that is sponsored by the Ministry of Education and AICT. We have also got selected for the celebrate the Amrit Bimars Viksit Bharat Dialogue, and we celebrate the Chandrayaan Mahotsav, also event driven by the AICT. We have also hosted the School Innovation Contest 2024, that is also sponsored by the Ministry of Education and AICT. We have also hosted the IDE bootcamp for the PM Sri School, KV Schools principal, as well as Government Inter-College School teacher in 2024, sponsored by the Ministry of Education and AICT. We have received several grants for organizing entrepreneurship development program that is sponsored by the DST. The School of Biomedical Engineering The School of Biomedical Engineering is led by the Professor Rajna Patnaik, who is the Dean of the School of Biomedical Engineering. The school have several programs and have an eminent and distinguished academician from all over the India. The Rajna Patnaik, our Dean, is the alumnus of Banaras Hindu University and ex-professor of IIT BHU Varanasi. The school offers finest education in biotechnology, medical biotechnology, nanotechnology, clinical research, clinical nutrition, forensic science, and healthcare management. The faculty of our school are dedicated educationist and researcher. The school is contributing toward the global biotechnology and forensic science research by ensuring several research publications every month and every year, both nationally and internationally in the SCI Index Journal. We have also developed several patent technology and organized several workshop and knowledge enhancement of the faculty and student. The school believe in educating in the students and empowering them with the deep technology knowledge of their particular domain, which can be further applied in current healthcare research and industry to elevate to the next level. I would like to invite our Dean, Professor Rajna Patnaik ma'am, to kindly address the gathering. Over to you, ma'am. Ma'am, you are muted, I think. Ma'am, you can unmute yourself, please.
A very good morning and a very warm welcome to our keynote speaker, Mr. Vijay Kumar Makyam, and all the participants who are attending this. I thank Dr. Gaurav to take such an important topic, IP management for startups, which is the need of the day. As we know, that the intellectual property rights refers to the legal rights that protect our creation of mind, such as inventions, literary and artistic works like music and art, designs and symbols, name, images used in commerce. The strategic handling of these rights to protect and capitalize our intellectual assets is managed by this IP management. And our today's speaker will talk about this. With these few words, I wish happy learning to all our participants and will request Gaurav to start the session.
Thank you.
Thank
Thank
you
you
very
so much,
much.
ma'am, for your kind words. So I would like to invite Slok Jindal, sir, the event coordinator, so to introduce and welcome our speaker.
Thank you, sir, and a very warm welcome to Gaurav, sir, to Vijay, sir. And thank you so much, sir, for accepting our invitation to be speaker for our today's session. And before starting, I would like to introduce our speaker. So, Mr. Vijay Kumar Makyam was a practicing IPR attorney. He enrolled with the Karnataka Bar in the year 2005 and got it transferred to Telangana Bar in the year 2014. He is registered patent and trademark agent for the Indian Patent and Trademark Office. He is a postgraduate in law with specialization in intellectual property rights and Master of Science in Information Technology. Sir is a guest faculty at NIMSME Hyderabad, NIPER Hyderabad, and also a resource person for University College of Law, Osmania University, JNTU Hyderabad, JNTU Kakinada, and Ministry of MSME. Mr. Vijay Kumar Makyam has attended JPU training program year 2017. Sir is also an in charge for registration of copyrights and trademarks, drafting, filing patent applications, and processing them in India, as well as coordinating, filing, and prosecution at USPTO, European Patent Office, etc. He was instrumental in organizing internal and external seminars and training sessions for IWIN IP services and IP markets. Mr. Vijay Kumar Makyam was a member of INTA, which is International Trademark Association, and AIPPI Anti-Counterfeit Committee member for 2016-2017. Sir has also worked as a technical member with Intellectual Property Appellate Board, a tribunal for IPR disputes from September 2020 till 4th April 2021, after which the board was abolished by Government of India. Currently, Sir is serving as a member for District Consumer Disputes Redressal Commission, MIDAC, at Sangareddy. So with this introduction, I would now welcome Sir to present his talk.
Thank you. Thank you for inviting me, Dean Madam Gaurav, and I'm happy to be here on this World IP Day. Let me start my presentation.
Yes, sir. Sure, sir.
Hope everybody is able to see the presentation. Yes, no?
Yes, sir. Yes, sir. Sir, you
Okay.
can close this small window.
Yeah.
Yes.
Is it now okay or still you're? Yeah.
Yes, sir. Yes, sir. Great, sir.
Fine. So before I move ahead, I would like to give a formal disclaimer that this presentation is only for educational purposes. It is not a professional advice and all. And the views, thoughts, opinions, statements expressed by me are only for the purpose of educational. They need not represent the organizations I am representing. Today we are celebrating World IP Day. World Intellectual Property Day is celebrated annually on April 26. The WIPO in the year 2000 to raise awareness of the impact of patents, copyrights, trademarks and designs in daily life and to celebrate creativity has declared World IP Day. This day, April 26, is when WIPO convention has been signed and WIPO World Intellectual Property Organization has been established. To commemorate the establishment of World Intellectual Property Organization, we celebrate this day as World IP Day. And this year, the theme for World IP Day celebrations is Intellectual Property and Sustainable Development Goals, Connecting the Dots. So if you remember, the UN, United Nations, has proposed this 17 sustainable development goals, that is no poverty, zero hunger, good health and well-being, quality education, gender equality, clean water and sanitation, affordable and clean energy, decent work and economic growth, industry, innovation and infrastructure, reduced inequalities, sustainable cities and communities, responsible consumption and production, climate action, life below the water, life on the land, peace, justice, and strong institutions, partnership for these goals. These are the 17 goals that have been set up by the United Nations. So this year, the World Intellectual Property Organization felt that achieving these goals through intellectual property rights would be the appropriate theme for celebrations of World IP Day. So sustainable innovation, creativity will definitely contribute to for the purpose of sustainable development goals established by the UN, United Nations. There is a poster that has been released by Indian Patent Office today as World Intellectual Property Day, and they are rightly kept this sustainable goals of 17 goals on a tree with the roots as patents, designs, trademarks, copyrights, GI, and semiconductor and integrated circuits. So this image gives you a lot of meaning. These sustainable goals can be achieved by these IP rights. Coming to today's topic, advancement in technologies and patent law, how patent law will help achieving the sustainable development goals of United Nations and how you need to acquire these rights I'll be focusing on. So advances in technologies, what type of technologies have come up of late and how they have been protecting. I'll also talk about the basics of what is an innovation and invention, how it is different from innovation is how different from invention. How do we define invention? Basic economics of intellectual property rights and how to safeguard innovation through IPR. And I'll also talk about artificial intelligence, software, IoT patents and issues surrounding the same and anything else that you want me to talk on. the first thing is we need to understand when we get a IP right, what is that we are getting? We are getting some economic monopoly right. Is it only individual centric, or by protecting IP rights, what you are contributing to the society is need to be monetary by your creation and your R&D and your things. If you have contributed something to intellectual property, that will enhance the development of the society at large, thereby eradicating the poverty and other sustainable goals that United Nations has propounded. And then you will generate income for yourself as well as income for the country. So if you have a innovative idea and you have not filed a patent application and you let it go, and thereafter some foreign company will come and file an application for the same invention and they get it patented. Once they get it patented, we need to import the technology to India. So when you are importing the technology, you are paying royalty to them. So the idea what you had would have fetched that royalty, would have not allowed you to pay that royalty money to the foreign company if you have filed and made it as a prior art or already existing technology. Then the other company would have not got this patents or this IP rights, and they would have not forced you to pay the royalties. So it is equally important, not only for your benefit, for the country's benefit, for foreign exchange and all. You need to understand the economics of intellectual property, which essentially ensure progress of science and technology. Individual monetization anyways happens, as well as overall country development will also happen. Utilization and commercialization of intellectual property generally happens. See, when you acquire IP, right, you'll use it for your own purpose, or you license it or assign it to some third-party company to get monetization. In case it is a trademark or something like that, you will give franchisee system. And if it is something like Disney characters and all, you'll give character merchandising. So there is this woman called J.K. Rowling. She wrote Harry Potter novels, 8 series of books. And then she has given it for making a movie. And after making the movie, each character she has tried to merchandise. Now she gets every minute, every second, lakhs of rupees will be going into her account because of this character merchandising and licensing of her assignment and licensing of her creative work. For a common person like you and me, the professors and students in the college, generating an IP may be a pride and maybe it is related to your academic activity. However, for a businessman, it is intellectual property means intellectual property has to be commercialized, the brand value to be enhanced, R&D investment has to be kept, new inventions has to come up, and so on, the business has to go on. So it is commercialization is what paramount important for businesses on intellectual property. So what should companies do to protect their intellectual property and avoid infringement of others' intellectual properties? The first step is they need to know what are the different types of intellectual property rights, and then only when you know there exists patent, trademark, copyright, design, and all this variety of rights, then only you can go and file an application. So first step is know what are various types of intellectual property rights. Then second step is whenever you get these type of intellectual property right, whenever you create or whenever you innovate a right that can be protected, you file an application before a
I think sir has lost the connection.
Tries to copy it. So what you need to do is you need to send cease and desist notices, enforce your rights against others. Stop, ask other, with your permission, there is no problem. Without your permission, if somebody is trying to copy your technology or trying to copy your work, then you need to stop them. So at the same time, when you are asking others to stop using your work, you need to respect third party, you need to respect others' intellectual property and avoid using others' intellectual property into your work. Should take care while using third party products, and while releasing a product in the market, ensure that you are not infringing third party rights. What happened to Kodak? I'll explain. Kodak is a world famous company, multinational company, which is involved in camera related products. However, Kodak is fast in releasing the products in the market. So they have invented a product called instant camera, and they have released the product in the market. PolarID is another company which is also into camera related products, and they have filed a patent application for this instant camera, and which is granted to them, not knowing that PolarID has a patent right. Kodak has released this product in the market and made huge profits to them. Then PolarID went and filed a case in US Supreme Court. The US court has awarded $930 billion to be paid by Kodak to PolarID. So by paying that huge amount, Kodak has become bankrupt. Had they verified before releasing the product in the market, if there are any patent rights to any person, they would have either sought a license from PolarID or waited for patent expiry of PolarID before releasing in the market. They have not done so, and they had to face the penalty of $930 billion. Thereby, they become bankrupt. So IP, at the same time, when you protect it properly, like JK Rowling, you can make huge money. And if you neglect it, if you don't protect IP properly and neglect the IP, you have to end up like Kodak, which is bankrupted by paying $930 million. So sometimes what happens is, since we are students or startups, we need a lot of funding, or we need people to test our product, certify that there is really an invention and all. So for that, we require to disclose the idea. The best method, what I recommend, is you file appropriate application and then disclose to investor or a fabricator, whoever it might be. Even if your friend, your wife, whoever it might be, don't trust anybody. Just file an application, get it secured for you, and then disclose to others. That is the primary mantra. If in case you are unable to file the application and you're required to disclose it to third parties, then ask them to sign a non-disclosure agreement. The non-disclosure agreement between the parties will say that whatever you are disclosing, for what purpose you are disclosing, you should use the material only for that purpose, and you should not disclose the idea outside. So once that agreement is signed, if he discloses outside, he is liable for payment to you for the breach of the non-disclosure agreement. So the first step I said you need to understand is various types of intellectual property: patents, trademarks, copyrights, GI, industrial designs, layout designs, topographies of integrated circuits, plant variety, traditional knowledge. In some countries, there are utility models, biodiversity, the new concept of traditional cultural expressions, databases, computer programs. There are variety of IP rights that have been developed. Most importantly, most people feel that patent is intellectual property is patent. It is not correct. Intellectual property is a wider terminology for all this variety of rights. Now we'll discuss about what is innovation. Invention is a mechanical or the physical aspect of technical accomplishment, whereas innovation is more complete package. Innovation includes not only invention, but also includes other organizational and social aspects of the invention taking into the market. So invention is only one aspect. Innovation is a complete comprehensive thing which will take the product into the market. So invention is part of innovation. So there is this magazine called Idea Pharma. They defined invention as bringing ideas or technologies together in a novel way to create something that does not exist before. That is the prior art, which is the technology which is existing. Or you come up with a new invention, then it is called invention. Innovation is written on invention creation of a meaningful value from the invention. So innovation is how to implement that product into the market. That is innovation. So invention is formulation of new ideas and for products and processes. Innovation is practical application of new inventions into the marketable product or services. So the myth and reality is, myth is only innovation happens in educated people in urban areas by doing lot of R&D research and all. But reality is innovation does not relate to education or urbanization. It can happen anywhere and everywhere. Even in rural places, you can have inventions happening. I would like to say that not all innovations need workshops and brainstorming sessions or big budgets. There can be out of the blue an invention and innovation can happen. If you see this slide, uh, this I have taken from Professor Fawn Mamadi presentation. So he says that the bullock cart has been replaced with the front of the lorry. So it saves him from rain and everything. See, the soldiers were on their move and they want to have food and they want to burn the eggs to make omelets. So they have used their instruments as frying pan. These people here in these pictures, one person made the chain as bed and the other person made the bottles as a stool to sit on. This guy is cleaning the road. Somebody has made this. So what I'm trying to say here is innovation does not really require huge budgets and all. The way we are using the technology today, if you think differently, automatically you get a new invention. There are several Jugaad inventions in India. This guy in a bike, where only 3 people can travel, he made 9 people to travel. This mother has kept a chair for his kid on a scooter. This guy used yoke for tightening the belt. This guy used mirrors to the helmet. Here, this guy is sending bricks from the top to bottom. So he used 2 sticks and he kept a old tire so that bricks won't broken and fall into the carriage there without breaking them. So it's kind of, so what I'm trying to say here is the work need to be achieved. So you need to think innovatively to achieve the task. That is what is innovation, and innovation need to be sometimes you make a great product, very new technology, but that doesn't though it is excited for the people like here have shown. Generally we have a mission eater. Here the inventor has made a bucket which has inbuilt emission heater. So it was well received by all the people, but nobody paid for it. Nobody purchased the product. So the product got failed in the market. So it is not product market fit. So innovations may be the great inventions. People may be excited to see your innovation, but what is innovation? The inventions can be exciting to them, but what is innovation is if the invention product market fit, then it will be called as innovation. So we need to have systematic approach to evaluate the commercial viability of products which have become invaluable to us, and that require to be made and then filed applications for protection and get commercialization. In a nutshell, I would like to explain in this slide what are the rights for what it will be granted and how it is accorded with a pictorial example. Patents for all new inventions, maybe product or process inventions. It is provided by filing an application and examination done by the patent examiner, something like a machine. Copyright for original creative or artistic forms like literary works, artistic works, musical works, sound recordings, computer programs, all this will come under copyrights. It exists automatically. You don't require to file any application to get protection. The moment you create, the moment I write a poem, a copyright to it. I don't require to file any application to get protection. The only thing is I need to recognize it as my IP right when it is published, when it is circulated. That details I need to record and keep it for me, so that tomorrow if somebody copies, I can say that I am the prior creator of this work. Then trademarks, distinctive identification of product and service. A trademark, the name itself connote the trade means business, mark the representation of a business. So that is been protected. The how it is given protection, most often what happens, people not even knowing that it is a mark, they use it in on their products and sell it. Over a period of time, people associate that name or that mark to a particular organization. So since they have not registered, there is no protection to them. No, even without registration, only by using, you get protection to the trademarks, as well as and or you can file an application and get it registered. For example, Google as a brand name, we all know. There is a saying that all their physical assets together, if they sell also, they can't equate the brand value of Google. That is the value of the brand. Then registered designs, I'm saying the name itself connotes registered designs. There is no, unlike trademarks and copyrights, it doesn't exist automatically. You need to file an application to get design registered. Design is an extension of the copyright. Generally, if you want to make a product, you make a painting or artistic work on a piece of paper and apply the design to the product, right? So when you make a piece of paper and draft it on a piece of paper, then it is artistic form of expression that gets protection under copyright. The moment you make this artistic expression to a product and apply to the product more than 50 times, if you make the artistic design and manufacture a product for more than 50 times, then the copyright ceases, and if you have registered as design protection will be given to you. Design registration is given to the external shapes. External, if you have a product, if you have a shape inside the machine, that will not be protected. It is only outside external shape, which is eye-catching, which doesn't have any functional value, that will be protected under designs. Registration is mandatory. Then trade secrets, any valuable information not known to the public. The condition is it should be valuable information to your business, but it is not known to the public. If it is known to public, there is no secret in it. So it is kept as secret and you alone know. For example, we have Coca-Cola formula, we have KFC's formula, recipe formula, and then in Coimbatore they make the undergarments, the procedure of making the undergarments, the weaving of the cloth, that itself they kept as a secret. So these are the secrets which are valuable for your business, not known to public, and you can keep it as secret as long as you want. Patents, it is only for 20 years. Copyright, it is lifetime of author plus 60 years. Trademarks, it is 10 years protection. Every 10 years you can renew indefinitely as long as you use it in the market. Registered designs, it is initially 10 years, thereafter 5 years, 15 years protection. Trade secrets, as long as you keep it secret. So all these are protected for a specific duration. After that duration, it goes in public domain and everybody is free to copy the technology without paying any royalty. There are certain overlapping IP rights. Copyright, as I said, copyrights and designs. Copyright, you get initially when you paint it on a piece of paper, you get copyright. And when you apply it to an industrial article by industrial process, then after 50 products, it becomes design right. Likewise, when you make a design, a symbol or kind of a thing which represent your business, initially when you make a painting, then it is artistic work protected under copyrights. And later on, if you associate that with the business, then it becomes trademarks. So you'll have a copyright as well as trademarks. Then sometimes you write your literature on the patent, and that can be copy. Like if you only write an article, it is a copyright work, right? When you able to you write a patent specification in such a way that the person who reads it can enable and manufacture that product, then it is patent. So it has both copyright and patents. So these IP rights are often confused. and some there are some similarities, but each of them are separate. If for one work, more than one IP can be applied. For example, here in one single product, there are multiple IP rights. The logo, trademark, the ring pull can, the technology of pulling the can out like this, there is a patent filed for that. The recipe formula, the image, artistic image, content, copyright, the external shape of the bottles as designs. So there are multiple IP rights for one single product. If you file patent, that itself does not sufficient. You need to file all types of, you need to explore, leverage all types of intellectual properties, designs, trademarks, copyrights to build an IP portfolio, and that IP portfolio will protect you better way in the market. Now let us check. Likit is a software developer in a company called Promax AI Services, which develops a product called GymFix that customizes gym equipment based on the user's body vitals. Computer automated physical fitness system. So this invention, the inventor Likit has wrote a book and he want to publish. But this Promax AI Services wishes to protect its IP before publishing the book. So you let me know what type of IP is available for this product. It is GymFix, the trademark. Then the equipment itself, a patent. Then he is writing a book, a copyright. So there are multiple forms of intellectual property that can be protected by that person, that company. Now, till here, I have emphasized on various types of intellectual property, and one single product will have multiple types, and you need to protect all types of intellectual property. Of all types of intellectual property, patents are paramount. Patent gives 20 years monopoly rights. Nobody can manufacture, sell, distribute the product without your permission. That is what a patent right. So the moment I say patent for a lay person, patent is a legal title granting its holder the right to prevent third parties from commercially using the invention without authorization. In return for this protection, the holder has to disclose the invention to public. So it is give and take policy. I'll give complete information about my idea, which is coming from my brain, to the society, and society represented by central government will give me monopoly rights for a limited period of time, that is 20 years. And for only in the country where I file an application, it is territorial. It is geographic specific area. Suppose you file application in India, you get only rights in India. You won't get rights in other countries like US, Pakistan, Bangladesh, and other neighboring countries also. You won't get the protection. So if you want protection in other countries, you need to file applications in other countries also and get secured your right in other countries as well. Now, for a legal person, when I say what is a patent, patent is the right to monopolize an invention. Inventor specifies the scope of activities which he want to exclude from others. That is what he says as claims. And he writes in the patent specification, these are my claims. I have invented XYZ featured machine. This XYZ feature is mine. I claim that XYZ machine is mine. And then patent office evaluate whether this invention, so-called invention by the patenter, the inventor, is really an invention in terms of patent law, whether it is correctly disclosed and industrially applicable. That is called formal examination. And some patent officers will also examine invention whether it is new, non-obvious. If they are new, non-obvious, it is substantive examination. If examination hurdles have been passed, the patent office grants exclusive rights to produce and market the invention for the period of 20 years. So that is how the claims, the invention will be evaluated in terms of claims written by this. There is no prototype that you are taking to the patent office. It is only the words you are writing in the specification. So you need to very vividly explain what is the product that you have invented in form of words. If you are unable to describe over the words, you can narrate using the drawings what is that you have invented. Only that you can submit. No prototype or no machine or thing need to be taken to the patent office. The patent office will read, visualize your product, understand what that is been invented by you, and then they'll grant the rights. So what not to do when considering to file a patent application for your new technology? You should not publish this information anywhere in the either internet or any publications, nothing, no publication should happen prior to filing patent application. If you file patent application, that's well and good. If you don't file patent application, you need to not publish until you file a patent application. No article, no press release, no conference presentation, no poster, no proceedings, no blog entry, no Facebook sharing, nothing. And no sale. Most often what happens is most of the clients come to me and say that we have a wonderful product we are selling in the market, and our customers, our clients are saying that this is a very good product that need to be protected under intellectual property, file a patent application, sir. You already sold in the market, that is already in public domain. When it is in public domain, though it is you disclosed, it has been gone in public, you can't protect it. Protection will be given.
I think sir has lost the connection. Shlok sir, please
Yes,
do the
sir.
message to the sir.
Yes, yes. I will call.
Vijay sir, you can switch off your video during the presentation. That's why your bandwidth is low. So
Right, I'm
yes, sir.
trying to do without the video.
Yes, sir. Yes, sir.
Hope
Yes, sir.
that would be fine.
Yes, sir.
Yeah. Are you able to see the presentation?
Yes, sir. Yes, sir.
Very good. So what I was asking is, when you are considering to file a patent application on a particular idea, you should not disclose this outside. No publication prior to filing. No article, press release, conference, poster, proceedings, a blog entry, not even Facebook share, not even disclose to anyone through online or offline mode. You should not sell the product incorporating the invention prior to filing. Most often my clients come to me and say that they want this patent to be filed because the customers suggested that the product is good. So once they sold the product, they will not have a chance to file a patent application. It is a different thing. Sometimes software companies will do beta testing and all. Beta testing is allowed, but actual product will not be allowed to sell. And no lecture presentation prior to filing except under NDA. If you have signed an NDA, you can share it, because sometimes funding and all, funding and prototyping and all, you're required to disclose. So that is allowed. Then I would recommend that the moment you get a patentable idea, seek a professional advice and file others before others file the application, because it is first to file system throughout the world. Earlier it was only in India, only in USA, but throughout the world now it is first to file system. Whoever runs first to the patent office and files an application, he gets the patent, not the person who filed later. Now, what are the requirements of patent? It should be, there is this popularly called non-test, novelty, utility, non-obviousness. But there are two S's, patentable subject matter and specification. Not all inventions can be patentable. There are certain no-nos. Section 3 of Indian Patent Acts lists several, section 3A to section 3P lists there are several things which are not patentable. And then section 4 says atomic energy is not patentable. Novelty, it should be new in light of existing technologies, that is current, whatever is existing, in that it should be new. So what we'll do is we'll check all the existing technologies and compare it with your idea. If it is matching, we'll say that there is no novelty. If it is not matching, then there is a novelty, we'll go ahead. And then it should be utilized in industry. By reading your specification, the person skilled in the art should be able to manufacture the product in the industry. We call it industrial application also. Utility in India, we call it industrial application. So your idea, whatever you have made, that can be industrially manufactured. If it is, if the person skilled in the art is unable to manufacture the product, then there is no utility. Then it should be, it should not be obvious, it should be non-obvious to persons skilled in the art. So if there are 2 or 3 things already existing, you combine those 2 or 3 things into one single product and claim that it is a new product, that is not allowed. So existence of 2 or 3 things, you merging it or combining it should have some kind of inventive step. Non-obviousness in India, we call it inventive step. So there should be some kind of inventive step to get a patent grant. So these are the requirements, and then the specification, you need to write detailedly what invention you have made. Once these 5 requirements are fulfilled, the patent will be granted. If you pour inventions from the top, it is like a filter. If it is patentable, if it is not patentable subject matter, it will be removed. If it is not having novelty, it will be removed. If it does not serve the purpose of utility, it will be removed. If it is obvious, then it will be removed. If the specification is not properly written, it will be removed. So only those things which qualify all this will end up in getting a patent grant. See this video now. Are you able to hear the sound of the video?
Hello.
Yes.
Hello.
Yes, sir. Yes, sir.
Hello, John.
Oh, yes. I've got lines here.
Well, fine, I guess. But how did I get here?
Well, let me show you. First, I'll need a drop of blood. Your blood.
Right. Oh, John, that hurt.
Relax, John. It's all part of the miracle of cloning.
Hello, John. Hello, John. Hello.
Hello, John. From what?
Hello, John.
Flow extractions never recreated a DNA strand.
Not without master sequence caps.
Good afternoon,
Your
John.
DNA from what source? Where do you get 100 million-year-old dinosaur blood?
Shh.
What? What? Oh, but it's the DNA. Where did you come from? From your blood. Just one drop of your blood contains billions of strands of DNA, the building blocks of life. A DNA strand, like me, is a blueprint for building a living thing. And sometimes animals that went extinct millions of years ago, like dinosaurs, left their blueprints behind for us to find. We just had to know where to look. 100 million years ago, there were mosquitoes, just like today. And just like today, they fed on the blood of animals, even dinosaurs. Sometimes, after biting a dinosaur, the mosquito gets sap. After a long time, the tree sap would get hard and become fossilized, just like a dinosaur bone. preserving the mosquito inside. This fossilized tree sap, which we call amber, waited for millions of years with the mosquito inside until Jurassic Park scientists came along. Using sophisticated techniques, they extract the preserved blood from the mosquito and, bingo, dino DNA. A full DNA strain contains 3 billion genetic codes. If we look at screens like these once a second for 8 hours a day, it'd take 2 years to look at the entire DNA strain. It's that long. Thinking machine supercomputers and gene sequencers break down the strand in minutes. And virtual reality displays show our geneticists the gaps in the DNA sequence. We use the complete DNA of a frog to fill in the holes and complete the code. And now we can make a baby dinosaur.
So is this idea patentable? What we need to check here, they have taken a drop of blood, analyzing the DNA and doing something and getting an extinct species to be life. So is it patentable or not? For checking that, what we need to do is, first thing is we need to check whether it is patentable subject matter or not, whether it is falling under section 3 or not. There is a particular provision under section 3 which says that plants and animals and parts thereof can't be patentable. If we really make a dinosaur, I can't patent it because plants, animals and parts thereof can't be patentable. So it is not patentable subject matter. So there ends the matter. Assuming that it is patentable, patent eligible subject matter. The next thing is we need to see novelty, whether it is the process of cloning or process of making extinct animal, creating an extinct animal from the drop of blood. Is it novel process or not? If it is novel process, there is no prior art existing. Yes, it qualifies. If it is already existing technology, maybe the movie Jurassic Park, when did the movie Jurassic Park has come? Way in 90s, right? So 20-30 years old technology. So if that kind of prior art exists, then it is not a new thing. So you need to evaluate novelty. After that, utility. Can it be manufactured in an industry, in a factory, or in a industry has wide connotation. Industry is not just a factory. Even your college, academic institution can also be called industry if it is used and manufactured. And then the third requirement is, fourth requirement is whether it is obvious or non-obvious for the person skilled. See, for a PhD guy, everything looks obvious, but an ordinary person skilled in the art, that otherwise it will not be granted patent. Then the specification, you need to write a detailed specification. I'll show you another video for about.
Supposed to start with these operation programs first. This major butter and shit. Let's do something a little more fun.
Pay attention to the language, go to the visual.
Combat training.
Here, what he is doing is he has that karate.
Jiu-jitsu. I'm going to learn jiu-jitsu. I think he likes it. About some more? Oh, yes.
To his brain. So can this kind of invention patentable? Again, the same thing you need to do. Whether it is patentable subject matter, novelty, utility, non-obviousness, and specification. All these 5 things when you evaluate are fulfilling or not. If it is fulfilling, then it is patentable. Otherwise, it is not. I have which shows there are multiple technologies, but I'll skip this. There is a BMW car. This is a James Bond movie, which has several technologies. Each technology, when it is being protected, all these 5 patentable subject matter.
Ja, mein Büro hat ein Auto reserviert.
Einen Moment bitte.
Dankeschön.
let us just see the car, how it is built, the technology, and then
If you just sign here, Mr. Bond. It's the insurance damage waiver for your beautiful new car. Will you need collision coverage?
Yes,
Fire?
probably.
Property destruction?
Definitely.
Personal injury?
I hope not, but accidents do happen.
They frequently do with you.
Well, that takes care of the normal wear and tear. Do I need any other protection?
Only from B007, unless you bring that car back in pristine order. Shall we?
Shall we?
Your new BMW 750. All the usual refinements. Machine guns, rockets, the GPS tracking system.
Welcome. Please fasten seatbelt and obey all instructions for a safe trip.
Thought you'd pay more attention to a female voice.
I think we've met.
I am not interested in your sordid escapades. Let's get on with it, shall we? Your new telephone. Talk here, listen here.
So that's what I've been doing wrong all these years.
Look, it also includes a fingerprint scanner and a 20,000-volt security system, and this I'm particularly proud of. The remote control for your car. Tap twice. 1, 2. Now, draw your finger very slowly across the pad to drive the car. Well, it's surprisingly difficult to drive, but with practice...
Well, let's see how she responds to my touch, AQ.
So a mobile operated car, can it be patentable or not? So the same things, 5 requirements you need to keep in mind. Whether it is patentable subject matter, whether novelty is there, whether utility is there, whether not it is obvious or non-obvious, and then whether you have written a proper specification or not. Based on that only the application will be accepted. As I said, it is quid pro quo. When policy disclose the issue, you will get the rights. The requirements we have gone through. Then what happens is the process involved is you need to do the moment you get the idea, you need to do a search to check whether it is already existing or not. If it is existing, you will not go ahead with the drafting of specification and all. If it is not existing, if you have complete information, you will file a provisional application. If you file a provisional application, you will get 12 months time to file a complete specification. This 12 months time is same for filing all foreign applications also. After filing application, you don't require any prototype designing or testing. Sometimes once you file a provisional application, 12 months is not sufficient for you to file a complete specification. You want to post-date your application, you can do so for 1 day, 2 day, up to 6 months. Up to 6 months, you can post-date your application. Once it is post-dated, once you file complete specification, the application is published for pre-grant opposition. If nobody opposes or if it passes to the examination, again, examination is done for subject matter, novelty, utility, non-obviousness and specification. If they are not meeting, they'll issue FER, first examination report. You will be given 6 months time to reply to the first examination report. If they are satisfied with your reply, they'll grant a patent. If they are not satisfied, they raise further objections in the hearing notice, and they'll invite you for a personal hearing. Earlier it was personal, now it is through video conference. Once you make your submissions in the hearing, you will be given 15 days time to file written submissions. Based on your complying with the objections raised by the examiner, patent will be granted or refused. Once patent is granted, it is valid for 20 years, and every year you need to file renewals and working of patent that you are manufacturing and selling the product in the market. Recently, patent rules have been amended. Now, working of patents on Form 27, earlier it is every year. Now they made it every 3 years. or whenever the controller asks for. Once the patent is granted, it is open for post-grant opposition for 1 year. And if nobody opposes within that 1 year, the patent will be going on. And anytime any person can file revocation application if it is not meeting the requirements of subject matter, novelty, non-obviousness, utility, and specification. Some timelines here. Provisional specification to complete specification, it is 12 months. Post dating of provisional application, maximum 6 months. Publication of patent specification, if you don't make a request for early publication, automatically it will be published after 18 months. Pre-grant opposition, once it is published, minimum 6 months controller will wait for the grant. Otherwise, if it is delayed for granting, then it will be until the grant you can file pre-grant oppositions. Examination application, request for examination within 48 months you need to file. Recently in 2024 the patent rules are amended, and now after March any application from April 1st, if you file any application, that has only 31 months for filing request for examination. After first examination report, reply 6 months. Grant refusal, post-grant oppositions, then renewals. Working of patents now every 3 years when controller demands. If you don't work the patents, it is subject to compulsory license. There is one compulsory license that has been granted in India, that is Bayer versus Natco. Bayer has a patent. They were not manufacturing in India. They are selling for exorbitant price. The Natco went to the controller of patents and sought for compulsory license, and they got a compulsory license. So I think we are running out of time, but I'll quickly run through a couple of slides and we'll close that. So these days, artificial intelligence, machine learning. Yes, sir.
Sir, you can take your time, sir.
No, I need to rush for another conference also. That's the reason I'll quickly wind up.
Okay.
Artificial intelligence, machine learning, and IoT related patents are on top these days. There are several applications of artificial intelligence in e-commerce, healthcare, retail sector, manufacturing, and self-driving cars, marketing, and business. So what is an artificial intelligence? How it is disrupting technologies? I'll leave the slides here. This AI and robot holding patent rights is the moot question. Can robot hold a patent? Can a person who can a computer can have rights? So earlier the issues were discussed, and they said that animals are like monkey selfie case. If you take the US court deliberated and said that animals will not have any rights, and animals can't be given any protection of rights. Likewise, AI also can't be protected, is what worldwide patent offices are saying. But however, this automatic content creation by the computers, if a computer writes a book, or if a computer creates a content, who should hold the patent?
Hello, my name is.
I leave this slide and the YouTube link. You can go through this video, automated content creation, wherein a PhD scholar who does research and writes a book in 2 to 3 years time. This computer. This computer. I'm sorry. Can some? I think there is voice coming.
Participant, please mute yourself.
Yeah, this software writes the book within 13 minutes of what PhD scholar can do in 2 to 3 years. So you can go through this patent. If you have any questions, maybe I'm open for questions.
Okay.
Again, World IP Day. Happy World IP Day.
Sir, thank you, sir, so much for this interactive, informative, and wonderful thought-provoking session. So now the session is open for the question answer. So dear participant, if you have any query related to IPR and their management, you can unmute yourself and ask your question.
Good morning, sir. Good morning, sir.
Good morning,
Yes,
sir.
good morning, ma'am.
Sir, am I audible, sir?
Yeah,
Yes,
yeah,
yes,
you
yes.
can go on.
Sir, this is Vasudha from Vignan Institute, Visakhapatnam. One of my
Yes.
student completed having an interest like he undergone this copyrights and everything, sir. He invented one tea bag. Instead of the tea powder, he just keep one more drug and he invented, sir. To get a patent for the topic.
For any invention, it is the same process, ma. It is like you need to check these 5 requirements, whether this is patentable subject matter, whether the tea bag, whatever is invented by them, is it patentable subject matter, whether it is novel product, whether any prior art technology is existing or not, whether it industrially it can be applicable or not, whether there is any inventive step or not, and then have you written a good specification. If you write good specification, definitely any product can get a patent.
Sir, any authority is there to support these people at the student level to guide them in right path?
There are Government of India has this startup facilitators. There are several startup facilitators who can help you in guiding them. And they can write to us. You can have my contacts. Ask your students to write to me.
Okay, sir. So, is it available in the college website, sir?
I request the organizers to share the PPT with everyone.
Okay, sir. Okay, sir. Definitely. Thank you, sir.
Yeah, one more question we can take.
Yes, any other query?
Somebody raised a hand.
Me?
Yeah.
Yes,
go
please.
On.
Yeah. Thanks for that informative session. So actually, I just want to know that as you're mentioning, sir, so how to get informed about that already existing patents and all that, that whether I am working in the direction that there might be a chance that somebody has already worked in that domain. So how to get informed about that?
There are a lot of databases these days. Earlier, when computer systems are not there, it was difficult. But now databases are connected. The popular free database is patents.google.com. You can just key in the keyword of your invention. You get the several patent applications. Then each technology is classified into patent classifications will be there. So international patent classification number you can identify for your technology domain and do a search with the keyword as well as international patent classification number to zero down the number of inventions that are already filed in the market and then compare them with your invention. And if it is new, then you can go ahead and file patent application.
Okay. Thank you. And one more question that you were mentioning about that the non-disclosure agreement that if there is a breach, so what are the penalties that one can impose on?
If NDA is breached, you can file a civil court, civil case. Law of torts allows you, and it is a contract because it is a contract. Breach of contract is always actionable in the court.
Okay. Thank you so much. And thanks to Dr. Gaurav for organizing such a informative session.
Sir, excuse me, sir.
Yeah, go on.
Sir, I am a BPharm graduate, sir. Just now, I'm pursuing my degree from Vignan College. I have an idea of a new drug, sir, new combination. And
I'm unable to hear you. I think the network is not proper.
Sir, excuse me, sir.
Yeah.
Sir, am I audible?
Yes, you are
Your
audible.
network is not
Your network
good.
is not good.
Maybe you can note down the email ID. My PPT will be circulated. All other participants may write to me. I'll be happy to reply back. If not immediate, within a day, you will get replies to your questions. Thank you.
Any other query?
Thank you, sir.
Yes. You can unmute yourself to ask.
I think, sir, we will go ahead
Yes.
with the proceedings.
Yes, sir.
Any
Yes,
other
sir. Yes,
questions,
sir.
they can
Yes.
write to me on the email. I'm sorry, I have need
Yes,
to rush
yes.
for another session.
Thank you once again, sir, for your precious time you have taken out from us, from your busy schedule for us. This session is very valuable, very informative, sir, and I hope the participant have got some new learning. And I would like to invite our dean, Professor Rajna Patnaik, ma'am, to kindly offer the e-memento to our guest of honor.
Thank you very much, Mr. Vijay, for such a nice, such an informative session. And thank you very much for accepting our invitation for this. And please accept on behalf of Galgotias University this memento. Thank you very much for your sparing your time.
Thank you, madam. Thank you. Can I exit, sir? Am I permitted to leave?
Yes, sir. Yes, sir. Please. Thank you so much, sir.
Thank you.
So, dear participant, I have sent the feedback form link in the chat box. So you can find the feedback link in the chat box. Please fill out this form. And once again, I am thankful to all the participants for making this event great success. Thank you so much. Thank you, Rajna ma'am. Thank you, Slok sir, for organizing such a beautiful and wonderful workshop. Thank you.
Thank you, Gaurav sir.